I'm delighted to be here and would like to thank ODR Africa Network for inviting me to speak and share with you at today's knowledge sharing session on the new essential Lawtech and ODR for micro, small, medium-sized enterprises. Before we get into the topic, I am going to briefly introduce our organization so that you know where we are from and what we do. So eBRAM International Online Dispute Resolution Center is a law tech and nonprofit organization based in Hong Kong, focusing on the development of law tech services and online dispute resolution platforms. It was established in 2018 with the support of the Asian Academy of International Law, the Hong Kong Bar Association, and the Law Society of Hong Kong. And our vision is to offer a one-stop shop for commercial parties from all over the world by providing a deal-making, dispute avoidance, and dispute resolution online platform integrating the latest technology. eBRAM not only develops ODR platforms and provides ODR services, but it also administers cases like other arbitral institutions to ensure that the ODR process is conducted in accordance with eBRAM's ODR rules. eBRAM is also a qualified institution under the arrangement on interim measures between the mainland and Hong Kong, and I will further explain the importance of this arrangement later in the presentation. In June 2020, eBRAM launched its first ODR platform for the general public and businesses to resolve COVID-19 related low-value disputes involving at least one Hong Kong resident or one Hong Kong company at a fee of 200 Hong Kong dollars or 25 US dollars to be paid by each party to the dispute. In March 2022, eBRAM launched the Hong Kong Legal Cloud, providing the Hong Kong legal and dispute resolution professionals with safe data storage. In May 2022, having been listed by APEC as an ODR provider under the APEC Collaborative Framework for ODR, eBRAM officially launched its APEC ODR platform and its revised APEC rules. And today I will share with you how ODR and Lawtech can facilitate the resolution of cross-border disputes from micro, small, and medium-sized enterprises, MSMEs. As you know, various dispute resolution means are available. However, they're not necessarily suitable to resolve certain disputes, including low-value disputes. Apart from online meetings we're all familiar with, on what other aspects of the dispute resolution proceedings may technology assist? And to answer that question, I will also be sharing with you eBRAM's latest developments and how technology can be adopted to enhance efficiency in the provision of dispute resolution services. Why is ODR the new essential for MSMEs? MSMEs play a major role in many economies, in particular in developing countries. They represent about 90% of businesses worldwide and account for 50% of employment. MSMEs contribute to job creation and global economic development. They also contribute up to 40% of national income in emerging economies. In the Asia Pacific Economic Cooperation or APEC region, MSMEs account for over 97% of all businesses. The growth in trade has led to more cross-border disputes. However, according to statistics published by APEC Business Advisory Council, 94% of MSMEs reported that the lack of dispute resolution mechanisms was one of the greatest challenges faced by MSMEs when trading abroad. Another study on the use of ADR for business-to-business disputes in the European Union reported that over 35% of cross-border disputes involving MSMEs remain unresolved, with an average amount in dispute being 50,000 US dollars. What are the challenges faced by MSMEs when trading abroad? One of the biggest challenges is the lack of effective and affordable dispute resolution mechanism. Traditional means of dispute resolution, including court proceedings and arbitration for cross-border transactions, do not work effectively for MSMEs. A 2017 questionnaire to APEC Business Advisory Council and member economies shows that cost and time were the major challenges in cross-border disputes, as court systems may involve delays, high cost, unfamiliar, opaque, and complex processes. Further, traveling costs coupled with language and cultural barriers make it difficult for MSMEs to resolve their disputes effectively through domestic courts. MSMEs also face a lack of legal staff within their organization and lack of adequate financial resources to hire legal representatives and engage in legal or arbitral proceedings, which tend to be expensive and time-consuming. So when a dispute arises, MSMEs would need to seek external legal assistance, which may drain their financial capital. There is therefore a need for efficient and affordable mechanisms for resolving disputes in cross-border commercial transactions. And this is where ODR platforms come into play by providing MSMEs with an avenue to resolve disputes quickly and cost-effectively. According to the 2017 questionnaire to APEC Business Advisory Council, 74% of the respondents indicated that they would like to have the option of using ODR to resolve their cross-border commercial disputes. With the expedition of the COVID-19 pandemic and law tech development, the dispute resolution landscape has been transformed, particularly for cross-border disputes. The COVID-19 pandemic has impacted the way businesses resolve their disputes, and we have seen a greater use of virtual hearings, AI translations, document management platforms, and electronic signature. Legal and business professionals have also turned to digital technologies to facilitate their work. Online dispute resolution, or ODR, is an online process in which all aspects of the proceedings are conducted online through a platform from the filing of the claim up to the settlement of the dispute, either by mediation or arbitration. Parties may hold hearings, meetings, and exchange documents through the ODR platform. Disputes may be resolved by negotiation, mediation, or arbitration. And if the parties fail to settle the dispute, at the end of the proceedings, a final and binding award rendered by the arbitrator will be notified to the parties through the platform. What are the advantages of ODR? ODR provides a more efficient and cost-effective way to resolve cross-border disputes for MSMEs. First, ODR overcomes geographical barriers. It is accessible from any part of the world and on desktop, mobile, and tablet. The ODR platform may also help overcome language barriers by providing AI translations. It therefore facilitates access to justice for people who have cross-border disputes but face language barriers. ODR is suitable to settle cross-border disputes because parties do not need to meet in person. They can resolve their disputes online from their respective locations and exchange submissions to the ODR platform. ODR is secure as all data uploaded on the platform are encrypted using bank-grade encryption. ODR takes significantly less time than traditional arbitration or litigation and involves much lower cost and ensures quick and affordable access to justice for MSMEs. Now, I would like to highlight the initiative undertaken by APEC to help global businesses to resolve cross-border commercial disputes by ODR, with MSMEs as the major beneficiary. In response to APEC MSME's need for affordable and effective dispute resolution means, the APEC Economic Committee endorsed in 2019 the APEC Collaborative Framework for ODR, which is designed to promote business-to-business cross-border confidence by providing quick online resolution and enforcement of disputes across borders, languages, and different legal jurisdictions. The APEC ODR framework provides a one-stop shop for online negotiation, mediation, and arbitration, ensuring access to justice for MSMEs. Hong Kong was one of the first economies to have opted into the APEC ODR framework in April 2020, and with the support of eBRAM, have participated actively in APEC workshops and webinars to promote the use of ODR in Hong Kong and beyond. In May 2020, eBRAM was officially listed by APEC on its website as one of the very first batch of ODR service providers under the APEC framework. Now, I'd like to introduce the APEC ODR system developed by eBRAM for resolving disputes and share with you the main features. So having been listed by APEC, eBRAM's ODR platform can now serve businesses in the APEC economies and worldwide, especially MSMEs, to resolve cross-border disputes within a secure environment and at a competitive price. In May 2020, eBRAM also published a new version of its APEC rules, providing more efficiency and transparency of the proceedings conducted under eBRAM's ODR platform. Now, what are the conditions of application? All businesses in APEC and worldwide can use the eBRAM platform to resolve their disputes in accordance with eBRAM APEC rules, regardless of the amount in dispute. They simply need to agree to refer any disputes to be resolved by ODR under eBRAM APEC rules. In terms of procedure, the eBRAM platform adopts a three-stage proceeding to be conducted within a short period of time. In compliance with the APEC ODR framework, the cost of the proceedings conducted under our platform are low, reasonable, and affordable. eBRAM ODR platform, the APEC rules adopt a three-stage procedure with online negotiation, mediation, and arbitration to resolve any disputes taking as little as 9 weeks to conclusion. If the parties fail to settle the dispute during the negotiation stage of the proceedings, a neutral will be appointed by eBRAM to conduct the mediation proceedings and the arbitration proceedings if mediation fails. Such appointment shall be made by eBRAM from its panel of neutrals, which comprises multilingual international commercial dispute resolution professionals from different jurisdictions and with expertise in a variety of sectors. While the proceedings are governed by eBRAM's APEC rules, these rules are practical and flexible enough to accommodate the needs of the parties. The parties may enter into settlement discussions anytime during the ODR process. To resolve disputes by ODR under eBRAM's APEC rules, parties must agree to settle any dispute arising within the scope of the APEC ODR framework in accordance with eBRAM APEC rules, and they can simply include eBRAM's model clause into their contract or agree in writing after any dispute has arisen. There is no requirement as to the nationality or location of the parties. And we have a dedicated web page explaining the APEC ODR process. And to start a case, you simply need to create an account on the APEC ODR platform and file your claim and upload your supporting documents online. For more details about the APEC platform and rules, you can visit our website to see those details. So what are the features and what type of platform it is? So it is a technology-based platform with a human element for the administration of the cases and the decision-making. eBRAM administers each ODR case in accordance with eBRAM's rules to ensure due process and fairness. Our platform is entirely web-based and equipped with an array of advanced technologies and features, including blockchain and eKYC technology, that is the Know Your Customer technology. All files transfer logs are stored in blockchain-enabled immunity storage. eKYC, the Know Your Customer technology, will be used for first-time registrations to verify the identity of the parties. In addition, the platform offers a highly secure video conferencing system, allowing meetings and hearings to be arranged anytime on the platform, a communication box providing parties and neutrals with a convenient communication channel. Parties can compose a message or upload a document on the platform. The neutral may also communicate practical information to the parties through the neutral post function. Parties can use the AI machine translation to translate any documents uploaded and exchanged on the ODR platform into their preferred languages. If the parties reach a settlement agreement during the proceedings, they can sign it using the e-signature system after uploading the settlement agreement. The platform also includes a calendar for relevant dates and deadlines, an online and secure payment system, and a cost calculator to give the parties an estimate of the likely cost of the proceedings, calculated on the basis of the amount claimed. So eBRAM launched the COVID-19 ODR platform in June 2020 and the APEC ODR platform in May 2022. It is currently working on the development of 2 additional platforms to resolve disputes by online mediation and online arbitration. In June 2021, eBRAM also issued various sets of rules, including the online mediation and online arbitration rules, providing a structured framework to ensure transparency, efficiency, and fairness in the ODR processes conducted on its platforms. eBRAM's online mediation platform can help parties reach a settlement. Through the mediation platform, parties can exchange documents and conduct their mediation sessions with the mediator by video conference available on the platform. eBRAM's online arbitration platform is a neutral way to resolve disputes effectively and deliver awards that are enforceable. The online arbitration adopts a streamlined process. eBRAM's arbitration rules provide in this regard that the arbitral tribunal shall fix time limits not exceeding 45 days for the submission of the written statement of claim and statement of defense. At the end of the proceedings, a final and binding award rendered by the arbitrators will be notified to the parties through the platform. All ODR proceedings conducted on eBRAM's platforms will be administered by eBRAM's case management team, who will ensure that the process is conducted according to its rules. So businesses will be able to use the additional ODR platforms to resolve their disputes quickly and at a reasonable fee, either by mediation or arbitration, with no limit as to the amount in dispute, the type of dispute, the industry involved, or the location or nationality of the parties. When resolving disputes by ODR, parties can choose between an online negotiation, e-mediation, or e-arbitration, or a combination of all 3 modes. Now let's look at the benefits of resolving disputes on the eBRAM platform. First, eBRAM offers a reliable and secure platform that is protected by the highest level of cloud security. All data are encrypted during the transmission process and when stored in data centers. Our network also complies with international cybersecurity standards, and all users' accounts are protected using a multi-factor authentication. While the proceedings are governed by eBRAM's APEC rules, these rules are practical and flexible to accommodate the needs of the parties who can jointly nominate the mediator or the arbitrator or decide to negotiate, enter into mediation stage anytime during the ODR process. eBRAM has a panel of mediators and arbitrators comprising multilingual, international experienced commercial dispute resolution professionals. And eBRAM offers an ODR platform that is user-friendly, fair, affordable, confidential, and innovative, aiming at resolving any disputes quickly. Now, I'd like to say a few words on the arrangement for court-ordered interim measures in aid of arbitral proceedings entered into between the mainland and Hong Kong. eBRAM has been listed as one of the 6 qualified institutions under the arrangement on interim measures. This is another key element that parties must consider when choosing arbitration rules or ODR providers. Because with this arrangement, parties to an arbitration conducted on the ODR platform under eBRAM's APEC or arbitration rules with a seat of arbitration in Hong Kong can apply to the mainland Chinese courts for interim relief against mainland-based counterparties. And Hong Kong is the first and only jurisdiction outside mainland China where interim measures can be directly sought from the mainland Chinese courts. So to benefit from this arrangement, parties must agree to an arbitral proceeding seated in Hong Kong and administered by one of the 6 qualified institutions, including eBRAM. At the same time, there may be some concerns over the use of online processes, including as to confidentiality and privacy, the environment of the ODR process, leakage or breach of data, data security, and cybersecurity. Now, how does eBRAM platform address these concerns? eBRAM adopts a stringent cybersecurity protocol to ensure the safety of the system and network. A secure video conferencing system locally developed by eBRAM has been integrated into the ODR platform and is available for the parties' use throughout the proceedings. eBRAM also employs highly secure encryption and blockchain technologies to all its ODR platforms. We also apply eKYC technology and multi-factor authentication during the e-signing and registration process. Users are required to go through the eKYC procedure when filing a claim with eBRAM. And we use the best range of signer verification options, eKYC and one-time password to eliminate the risk of signature fraud. The e-signing process is tracked securely and safe in a secure environment with the document hash value protected by blockchain technology to prevent file amendments. I will now play a 4-minute video showcasing eBRAM's ODR platform.
With the eBRAM APEC ODR platform, you may resolve your cross-border commercial dispute with any claim amount securely, anywhere, at any time. To start with the platform, you are required to create an account by registering with your email. Enter your email, then click Send Verification Code. A verification code will be sent to your email. Enter the verification code and press Verify Code. Then enter your password and confirm the password to create the account. Once the sign-up is successful, you can log into your account on the sign-in page. To protect your privacy, a verification code will be used every time you log in. Check your registered email for the verification code. Enter your password again to log into the platform. Once you are logged in, agree to the terms and conditions and the personal information collection statement to proceed. You have now successfully entered the platform. Fill in the information of the dispute step by step, including the details of the claimant, the respondent, the representatives if available, and the case details. Then upload your supporting document. Once you finish filling all the information, a notice of claim in PDF format will be created. Sign the notice of claim online with eBRAM's e-signing service to proceed. You have the option to use the e-signing service with your computer or with your mobile device. Once you signed, an estimated cost will be shown for your acknowledgement and payment as a claimant. Payment options are Visa, MasterCard, check, or bank transfer. If paying by check or bank transfer, please upload image of payment. If you wish to pay later, click Go to Case Portal. You will then be prompted to verify your identity with the latest eKYC authentication technology. Use your mobile device to scan the QR code. Select to use your Hong Kong ID card or passport. Scan your chosen identity document. Press the blue button to capture the image. Take a selfie to complete the eKYC authentication process. Your case is successfully filed. The respondent will receive an email notification for the case to continue the dispute resolution process. eBRAM APEC ODR Platform is your trusted ODR partner for cross-border commercial disputes. If you're interested in our platform, scan the QR code here or contact us to learn more.
So now let's turn to the potential of Lawtech for MSMEs. What is Lawtech? Lawtech is a term we use to describe technologies that aim to support, supplement, or replace traditional methods for delivering legal services or improve the way the justice system operates. What are the advantages of using Lawtech for MSMEs? First, Lawtech can help break down geographical barriers, especially when travel to face-to-face meeting is impossible. The parties and the mediator, arbitrator can communicate using the video conferencing system or text-based communication system available on the ODR platform. External experts can also be invited to join the hearing regardless of their geographical location. Embracing online meetings, cloud storage, and AI can create significant time and cost savings. Lawtech gives greater flexibility to the parties who can use and access the platform anytime, anywhere, from any device according to their needs and availability. And in proceedings where language could be a barrier to communication, ODR platforms can also offer real-time translation. And as a Lawtech company, eBRAM provides services including a secure video conferencing platform, e-signing system, AI machine translation, and a Hong Kong legal cloud. The Hong Kong legal cloud provides local legal and dispute resolution communities with safe and affordable data storage, as well as other online Lawtech services, including legal research platform and AI translations. Now, a few words on eBRAM's e-signing system. It is easy to use. Documents can be signed anywhere, anytime from any device on laptop or mobile phone. The system requires a two-factor authentication using the eKYC technology, as you've just seen on the video, and a one-time password to verify the identity of the user. The e-signing process is then tracked and recorded in the blockchain management system to prevent unauthorized file amendments. Further, eBRAM has developed an AI machine translation. It is a translation engine equipped with AI technology to translate legal documents. The machine has been trained with legal materials, including case law and court judgments. Translations are currently available in 5 languages, including English, Chinese in traditional and simplified forms, Russian, Arabic, and Spanish, with the option of a professional human translator to edit and refine the translation. More languages will soon be available, including Korean, Japanese, French, German, and Portuguese. The AI machine translation has been integrated into eBRAM's platforms, including the online dispute resolution platforms and the deal-making platform. And speaking of deal-making, eBRAM is currently developing a deal-making platform integrating technologies such as real-time translation and transcription, e-due diligence, and smart contract. Through the deal-making platform, businesses from all over the world can negotiate a deal, draft an agreement, conduct meetings, and share documents, consider eBRAM's model dispute resolution clause, and conclude their agreement online using eBRAM's secure e-signing system. Cybersecurity and data privacy are our priority to ensure protection of information and communications on our platform. So eBRAM offers a reliable and secure platform that addresses all security and confidentiality concerns. We enable the exchange of highly confidential files within a secure environment without the need to send them by email or other less secure means. Our network also complies with international cybersecurity standards. All users' accounts are protected using a multi-factor authentication. Our platform is protected by the highest level of cloud security, including firewalls, intrusion detection, and a 24/7 network threats monitoring. Regular independent tests and total system audits, including cybersecurity and assessment, are conducted by external certified security experts. eBRAM has been working on other projects to enrich its Lawtech services, including the development of an e-transcription and e-bundling system, which will be new features to add to the existing ODR platforms. eBRAM will launch its deal-making platform, online mediation, and arbitration platforms later this year, making eBRAM a one-stop shop offering deal-making and online dispute resolution services to commercial parties from all over the world. So resolving disputes through an ODR platform such as the one developed by eBRAM is therefore safe and convenient and ensure the resolution of disputes efficiently and cost-effectively. However, the uptake in ODR remains slow. The main obstacle for using ODR is a lack of knowledge. The UNCITRAL, APEC, and ASEAN, which is the Association of Southeast Asian Nations, have taken steps to promote the use of ODR. And to raise awareness and increase businesses' trust in ODR, regional and international organizations, as well as governments, should continue to take common initiatives to encourage the use of ODR and engage in capacity building through ODR workshops and trainings. It is great to see the platform that ODR Africa Network has created to exchange ideas and ways on how technology can be utilized to improve access to justice in Africa and beyond. We have seen similar initiatives taken by the Hong Kong government with the establishment of the Inclusive Global Legal Innovation Platform for Online Dispute Resolution, or the iGLIP on ODR, in collaboration with the UNCITRAL, to keep track of the latest developments in the ODR world and develop innovative legal tools to address potential issues. At the Hong Kong Legal Week last year, a workshop on ODR was organized, during which speakers discussed the opportunities and the value of ODR for ASEAN traders. And I will conclude by quoting one of the speakers, Michael Dennis. For MSMEs, which often face a lack of adequate financial resources to engage in lengthy legal proceedings, he said, ODR is not just an alternative, it is the only practical redress option. Thank you very much.
Hello, Pui-Ki. Thank you for a wonderful session. Thank you very much. Yeah, we have some questions in the chat room now, so I'll read them out. Please, if you have any other question, you can signify with the hand raised, or you can type it in the comment in the chat room. Okay, so Mrs. Morenike will be fine. They ask now, what type of ID is required to verify identity of parties, taking into cognizance different nationalities and issuing authorities?
So thank you for that question. So what type of ID? I think we have mentioned that in the video, right? It is, so the system can support Hong Kong ID and then all kind of passports of all nationalities. So you can use your passport to authenticate your identity.
So you don't necessarily have to be a resident or a national of Hong Kong. That's what I wanted to do.
No.
Okay, thank you.
No.
Thank you very much. Just have another question that once data are kept on submitted on the platform, where are they stored and how long are they stored for?
Yeah. So all data are stored in data centers in Hong Kong. And they are we keep data for 10 years.
Thank you. Okay. Thank you. Yeah, also we have, what if the respondent does not accept the mediation? What can be done? What do you do to encourage the mediation, or what do you do in situations like that?
So according to the APEC rules, if the respondent does not engage in the mediation stage, parties will be moved to the final stage, that is the arbitration proceeding. So they will have to go to arbitration to resolve the disputes. And the same neutral that has been appointed to assist them during the mediation proceedings will be also in charge of the arbitration stage. So that is innovative, because the same neutral will be acting as a mediator and the arbitrator.
So sorry, just as a follow-up to that, if they actually engage and the mediation goes ahead, would it still then be the same neutral who has engaged the parties in the mediation that will still do the arbitration?
That's correct. Yes, the same according to the APEC rules, and this is in compliance with the APEC collaborative framework for ODR. The same neutral is to conduct both proceedings. Of course, if the parties do not agree, we might have to appoint another neutral to conduct the arbitration proceedings.
And you haven't had issues with parties complaining about bias or lack of neutrality because the same person has gotten all of the confidential information. Have you had that from experience?
Not yet, because the APEC platform has been launched very recently, so we don't have any cases at the moment. But I do expect some concerns on that aspect, so we might need to deal with that issue. Yeah.
Yeah, because indeed that was also my question, Monique. How can we expect parties to accept sharing confidential information with the neutral who will eventually become the arbitrator? So yeah, access to information will be a concern probably, at least for one of the parties.
Yeah, so actually, I mentioned in my presentation that the APEC process includes a negotiation stage, right? So parties will be given the opportunity to try to settle the disputes themselves. And for that stage, all the documents exchanged during that stage of the proceedings might not be necessarily communicated to the neutral. So the parties have 3 days to object to the communication of the file exchanged during the negotiation stage to the neutral. So he only gets, or she gets, only the information exchanged during the mediation stage.
And what about discussions that took place between ex parte discussion with one of the parties and the neutral?
Yeah.
Yeah.
That is something that they have to figure it out, right, themselves, and agree. They would need to discuss about the protocol, right, on how they want to deal with the kind of issues if they have to go to arbitration.
Do the rules, sorry to be excessive, do the rules also flag these sorts of details to the parties in order to draw their attention from the beginning?
No. So I think we leave it to the parties to let us know, if they do not want to have the same neutral, I mean, we can appoint another neutral to conduct the arbitration proceedings. So it's very flexible in that sense.
Thank you, Pui-Ki.
And we also ensure that we have experienced mediators to conduct and assist the parties during the mediation stage, so that this kind of issue is brought to the parties' attention up front.
Okay, thank you. Do you have other questions? So I'm going to ask 2 questions together. Some ask, how do you charge? Do you charge based on the dispute, or is it a flat fee? And also, how do you do with exchange rates? Different currencies, different exchange rates.
So so the fees to conduct the proceedings on our platform are calculated based on the amount in dispute, but there's a cap amount for low value disputes. So under $100,000, there's a flat fee, and then for all other amounts above 100,000, there will be a registration fee to pay, and then an administrative fee for conducting the proceedings under eBRAM's platform. So we have our schedule of fees set out at the end of our rules as well. So it's transparent, and parties can also use our cost calculator to estimate the cost of the proceedings. But it's basically based on the amount in dispute. And you raise another question as to the exchange rate, right? So we charge in Hong Kong dollars. So the platform will convert any other foreign currency into Hong Kong dollars for the calculation of the cost of the proceedings. But as to payments, I think you just use the current, the conversion rate of the date of payments. Does that answer your question? Oh.
Yes, yes. Thank you very much.
Okay.
Thank you. So yeah, another question is the mediation binding on the parties, and can they challenge the proceeding?
The mediation, I mean, if the parties settle the dispute and they have signed a settlement agreement, they are to comply with the terms of the settlement agreement. And but if they go to arbitration and there's an award that is rendered, then that is binding and final.
But with the Singapore Convention that has just been signed, even mediated settlements agreement, including those that are conducted online, are binding for the countries that have signed and ratified the convention. So I want to believe that that would also help.
The question I have is, when you do arbitration, we know different countries have different rules. So which country do you use to say, okay, we can understand mediation, but arbitration, one country maybe they do the arbitration this way, the other country does this. How do you help, or how do you deal with that?
We have our own sets of rules. So arbitration rules, mediation rules, and the APEC ODR rules, which include 3-stage proceedings. So we have our own rules which apply and govern each arbitration proceedings conducted on our platform.
So does the disputant have to agree to the rules? Because if they are from two different countries and they say, in our country, this is how we do arbitration, and these ones are saying this is how we do it. So how do you bring them together to say this is the one that we're going to accept and this is the one we're gonna deal with?
So you're talking about the rules of the proceedings, right?
Yes.
Yeah, because if they want to use the eBRAM ODR platform, they will have to agree to use our rules. So since they have agreed, I mean, there is no further discussion, I believe, right? So they need to agree before using our platform. Otherwise, if there's no agreement, we cannot proceed with the case.
So this is
So
for the
what you're saying, the rules are binding. Before they even come to the agreement, they have to agree that whatever rules we come up with, whatever agreement, it will be abiding irrespective of where you come from, where you are, but you have to agree with this one so that we can proceed.
Yeah, there's a binding agreement because in the contract, the parties have, agreed to sign a contract in which they have included a dispute resolution clause using eBRAM's rules. So that is the parties' agreement.
So for the
Mireille?
I agree, but what about the substance?
The governing law, right?
Yes.
Yeah, it is to be decided by the neutral. If there's any, if there's no agreement on the governing law or any issues as to the governing law, the neutral, according to the rules, the neutral will decide.
So the arbitrator actually.
Yeah, the arbitrator. But
Okay.
under the APEC rules, we call it neutral. Yeah, but the arbitrator will decide on the law governing the dispute.
So it seems the arbitrator has more powers than the parties under the APEC rules, at least for arbitration. That's what it means. Because ordinarily it would be the parties to decide as to the substantive law.
Yeah, that's correct. But if there's no agreement, the arbitrator will have to decide.
Interesting.
It's similar to traditional arbitration, right, Mireille?
Okay, so another question. Do you collect the fees at the beginning before proceeding to the mediation or the arbitration?
Yeah, so we collect a filing fee during the registration stage, and then we collect within 7 days the administrative fee for eBRAM. And then once the parties move to the mediation stage and we are to appoint a mediator to assist the parties, then we will collect another advance to cover the neutrals fees. So in different stages.
Okay, thank you very much, Ms. Ta. Okay, any other question? Okay, Mires.
It's not a question. It's rather an observation to say, I'm enchanted to see that actually you are offering a complete sets of services, and quite interesting because it has lots of applications. So it's very interesting. It's too new to ask you for any feedback by the users, and the level of satisfaction, how long a procedure has taken. And so yeah, that would be interesting to know in the future, but congratulations, because it looks like it's a complete sets of services for SMEs and any user. And sorry if I missed the information, Pui-Ki. So it's only for SMEs, or can also, like, supermarkets are SMEs also, can be considered as an SME. What about
Yes.
individuals?
Yeah, they can also use the platform as well. Yes. So there's no limitation on that.
Okay, so between two private individuals, so between two individuals, if they, for instance, like
doing business together, that's fine. Yeah, that's the only requirement.
All right, thank you.
Ma'am, Ms. Moran,
Yeah, just as an add-on to what Mires said, and this is just also a comment or a question really. Do your rules have provisions for how long it should take? For instance, apart from the APEC rules on your system, how long you expect for a mediation to last? How long you expect an arbitration to last? Do you have a limit on time? Because I know for ODR, there's emphasis on savings in cost and time. And so that's important for you because you're using AI, you're using blockchain and all of that to be more efficient. So do you then, when you have neutrals involved, do you then give them like a timeline?
Yeah, so if we talk about the APEC 1 days, yeah, very short period of time, like 7 days, 10 days to conduct the negotiation stage for parties. They can extend that time limit once for another 10 days, so 20 days for negotiation. And then if we go to mediation, it's only 10 days. Parties cannot extend that, but if they agree, why not? We can, accept, right? And agree to extend the time limit if both parties agree with the mediator as well. And then for the arbitration stage, it's also 10 days for filing of submissions and conducting hearings as well within 10 days. And then from, the closing of the proceedings or the submissions of the last substantive submissions on the platform, the tribunal has 10 days to render the award. So very short period of times, within approximately 9 weeks. So from filing of the case up to the end of the arbitration stage is 9 weeks in total. But for all the proceedings for the arbitration rules, for example, after the notification of the request for arbitration, the respondent has 30 days to file the answer. And then once the tribunal has been constituted, the parties will have 45 days to submit their submissions. But the rules do not contain any time limit as to when the tribunal should render the award. So we are looking into reviewing and perhaps revising the rules in this regard to have, short time limits to encourage the arbitrators to render the award quickly and for the mediator to conduct the mediation proceedings expeditiously as well.
Do you have a time? Do you have time limit for maybe the local dispute with the international dispute?
Between the type of disputes or it is the same, and it's provided under the rules.
So if somebody was to adopt your system, because you're based in Hong Kong, for example, let's say in Africa, how would there be some adjustment, or is it just a matter of just downloading your system into this, or would there need to be some adjustment so that it can fit that particular region?
We can resolve any kind of disputes involving any parties from any nationalities, right? So if you're talking about providing a white labeling our platform for the use of other institutions, we can actually assist and, discuss about this, and then of course adapt and tailor-made it to your needs and in accordance with your rules as well. But if the parties have agreed to use our rules, including African parties, for example, they will have to comply with the time limits set out in our rules. But of course, the parties are free to agree to any other time limits, shorter or longer. We are very flexible on that. But we need both parties' consent in order for us to accept the revision.
Maybe my question is, when you went to APEC, did you have to
Yeah.
train them, tell them, how did you sell the idea to them so that they can accept your system and agree to use it? What kind of promotion did you have to do, or what kind of education did you have to do?
We need to do a lot of promotions, right? Via different channels, and we need to do trainings, workshops to train mediators, arbitrators to use the online platform. It's not difficult, it's user-friendly, as you have seen. We also need to do trainings, for businesses to include how to draft an arbitration agreement, how to include a dispute resolution clause into their contract. So this is the kind of promotions that we need to do. Since the platform has been launched in May 2022, we have just for the APEC platform, we have sent appeal letters to various Chamber of Commerce. We have institutions, organizations to introduce the services, in particular in the APEC region. But I think we can extend that to other countries as well, since APEC platform can also be used by other parties, right, around the world, and not necessarily those that are doing businesses in the APEC region. And I also need you to promote, of course, the use of ODR. And if you find it, useful for MSMEs, you can, of course, recommend APEC, or if you want to know more about this, how the rules, APEC rules work, we're happy to collaborate and, have a meeting with you to introduce our platform.
Thank you.
Thank you.
And this is maybe a personal question, but you're free not to answer, Pui-Ki. Do you have competitors for the time being in your region? Offering the same types of services?
So for the APEC one, so APEC has listed 3 other ODR providers. So 2 others, including us. So 1 in Hong Kong, and then 2 in China, including the Guangzhou Arbitration Commission and CTAC, who have also developed ODR platforms under the APEC collaborative framework. But otherwise, I don't think we have any competitors doing what we do exactly, because we are self-developing the ODR platforms. We have an IT team developing the system for us. So I work closely with them, and I supervise, what they do on a weekly basis and give comments. We try to improve the system as well. We do pilot run, we do testing by various lawyers, practitioners to help us and comment, give feedback so that we can improve the system.
Okay, because it seemed to me difficult for the time being, having seen the set of services that you're offering, it seems to me that no other institution currently seems to offer the same variety of services.
Yeah, that's probably true, Mireille. Yeah, I mentioned the Guangzhou and CITAC, but they are also arbitral institutions, right? They do the traditional arbitration. And they do also some online dispute resolution, but mostly in China. Yeah.
Hello, Pui-Ki. So we have 2 questions on law and enforcement. Someone asks, with respect to enforcement, suppose a party is a Chinese national residing in Hong Kong. Can the platform assist in any way in enforcement in Hong Kong against the Chinese national?
So the platform does not assist for enforcement because we assist and we supervise the case up to the rendering of the final award. So once this is rendered, it is for the party to seek legal assistance for the recognition or enforcement of the award. But China and Hong Kong have entered into arrangements for enforcement of awards. So I do not anticipate any difficulties in enforcing awards when the seat of arbitration is Hong Kong. That's why parties, I think, need to consider when drafting the contract and dispute resolution clause, they need to consider the place of arbitration, the seat of arbitration, the governing law, and the institution, of course. As I've mentioned, there is also this interim measures arrangement, which is a game changer because parties, if you have your counterparty is in mainland China and you want to seek interim relief, you can directly go to the Chinese courts to seek interim relief. But you need to have an ongoing arbitral proceedings conducted in Hong Kong, seated in Hong Kong, in order to benefit from that arrangement. So these are considerations that parties should take into account.
Okay, thank you. The last one, I think we're talking about the governing law. Can we say that the rules that will apply will be where the dispute arose from?
I mean, that would depend on the facts and circumstances of the case, right? And it will be for the arbitrate. So I can't tell you now. It's right. Morenike agrees with me.
Okay. Thank you very much. Thank you for this
Thank
session.
you.
I'd like Mireille,
very
the member of our advisory board, to thank you. Mireille?
Yes, thank you very much, Vicky. That was excellent and very promising. So let's see how it evolves. But yeah, it's an interesting set of services that you're offering. Thank you.
Thank you very much. Thank you.
Thank you. That was very good.
Thank you very much.
Yeah, it was a wonderful session. Thank you. And thank you for making out time. I know it's 11 p.m. there, so thank you so much.
No problem. It was a pleasure to be with you today. And thank you all for joining us today. Bye.
Thank you. Bye.
Bye. Thank you.
Thank you.